able to, hopefully you're able to see and hear me all right here. This is a little bit of a new experiment for me on this platform today, but hopefully I'm glad you're all here and we can have a chat about intellectual property today. I've got a few slides to talk about basic intellectual property questions that you might have in your business, etc. And then from there, I want to welcome everybody to just, if you have questions as I go through, just to punch them in the chat window down in the bottom corner of the screen there, and I'll keep an eye on the window as we go and try to incorporate answers for you. Any of them, happy to follow up, telephone or email or something. From there, I'm just going to jump intellectual property questions that you might find in your business. There's different types of and it's good to kind of have a bit of a whether it's enumerate Mr. Patent and Trademark agent. I work in a firm called, very old to say that, but for 20 plus years. So lots of these things here, and a lot of the work that I do is with smaller companies, startup companies, and Saskatchewan companies that are first starting here and then sort of expanding their markets elsewhere in Canada and around the world. Some of the things I'm going to try to focus on and talk about today are first to give you a bit of a basic idea of the types of intellectual property that you might encounter. Then the two that we selected to kind of talk in a little more detail about are trademarks and copyright, because those are oftentimes topics that are of interest to the largest kind of number of companies. And speaking with Diane, we thought that these might be sort of a couple of basic concepts that would be good as a starting point for you and your projects. And then after we talk specifically about trademarks and copyright, I'll talk at the end, a few slides at the end, and we can have a little bit of a chat about how you might kind of identify and address different IP issues, and whether it be in trademark, copyright, or other areas in your company. So the first sort of area in which I would propose to speak for a little bit here is about trademarks. So in terms of trademarks, and this might take me a little, try not to jump around too much here, but with trademarks, we are in the unfortunate position as lawyers in the marketplace, but we're about to get an entirely new trademarks legal team in Canada coming up in June. So I will talk about here right now is sort of the trademark law, the way that it exists right now. But there's wholesale change coming to the trademark law in Canada in June. And so I'll try to reflect some of that in my remarks here, but if there are specific questions about how that might compare, etc., I've got my email at the end there, and you can feel free to reach out then on that. But generally speaking, a trademark is, I mean, in a traditional context, what people would think of as a trademark in their business would be any kind of a mark or identifier that you can use to identify the source of your goods or services. The Trademarks Act is in fact actually sort of scoped or it's created to actually protect the consumers in the marketplace, not the vendors, but it indirectly protects the vendors. But effectively, what it's all intended to do is to provide some certainty for consumers that they won't be confused within a particular channel of trade as to the type of the source of the goods or services they might buy. So typical background, people would think trademarks as sort of word marks, like the name of their company, like IBM or Microsoft or Google or something like that. or a logo, a design mark that you might use. So whether that's stylized text like the Coca-Cola label or something like that, or even like just sort of icons and things like that. So words and logos are two kind of traditional types of trademarks. Another word mark beyond sort of your house brand, so the name of your company or your product, might also be taglines. Lots of times companies will treat their taglines as trademarks as well. So text marks and logo marks are kind of the first two that you might be familiar with, and sort of as trademark concepts, those kind of reach back all the way into another Trademarks Act that we used to have before the one we have now. So they go back a long ways. There's also, in a more current context, been development in the law in Canada and around the world of different types of non-traditional trademarks. So there's additional types of trademarks that are out there in addition to sort of words and logos that are also things that you might find either that you encounter with third parties or that you might have in your business, in your own business, as you develop your business plan. So some of those non-traditional types of trademarks could include, and the first few here are protectable in Canada, but colors. So, the example, John Deere green, Caterpillar orange. UPS has a trademark registration for the color brown applied to a delivery truck. Colors are one type of a trademark that you could try to protect or monopolize in a particular channel of trade. Also, sound is another one. So, and sounds include lots of times the sound trademarks would be one example of a case that lots of people have heard of. This goes back about 15 years now and is not probably particularly timely law anymore, but the one that a lot of people have heard of would have been efforts by Harley Davidson in the US in the 90s, late 90s and early 2000s, to try and trademark the sound of the engine on a motorcycle. They weren't successful in that case, in large part because apparently the way that you could actually get your Harley to make noise that everybody recognized was with an aftermarket modification. But sound, in any event, that's one case that goes further back. Some other ones would be, the sounds that, lots of those sounds you would hear in Windows or as you turn your computer on, or video games or your phone, or those types of things. So sounds are another type of a denominator that you could try to monopolize as a trademark for your company. A third type of non-traditional trademark is to claim trademark rights in the packaging, so the packaging or the get-up of a product. So not the product itself, excuse me, but the sort of the shape or configuration of the packaging. So for example, a couple of packaging examples, and this is called a distinguishing guise. A packaging trademark is by and large treated as what's called a distinguishing guise under the Trademarks Act in Canada, and it's a couple examples of three-dimensional packaging trademarks could be, the glass Coca-Cola bottle, the Heinz ketchup bottle, those types of things that are recognizable, and that the package is recognizable. Two other kinds of non-traditional trademarks that exist elsewhere in the world, they're not so much in Canada at this point, but elsewhere in the world, would be smells. So the smell of something, and the origin of a smell trademark is likely. What started that in North America, there was a trademark registration for the smell of roses applied to knitting wool, believe it or not. So some company made their wool all smell like roses, and that was their trademark. The origin of smell trademarks really comes probably from France, where there's a strong perfume and cosmetics industry, and that would be kind of the origin of that there. Also tastes. So tastes can be registered as a trademark. So tastes of food items and those kinds of things. Going back to packaging for a second, another one that occurs to me beyond the packaging of a product, another way that people have used those sort of distinguishing guise or three-dimensional packaging or get-up type trademarks is actually to protect the interior or exterior configuration of physical premises. So, for example, franchise restaurants, the appearance and build out of a restaurant inside, for example, is one one company that has a whole pile of trademark registrations on that actually is Krispy Kreme donuts. Just the sort of the appearance of the exterior and the interior of the buildings. Subway also has done that some. So those are some types of non-traditional trademarks that you might have in your business and or might try to protect or encounter from time to time. In terms of in terms of trademark registration and sort of trademark entitlement, if you have something that you use as a trademark in your business, there's a number of rules that apply in terms of determining who has the. It's unlike in the patent system where it's basically completely a first to file system. The trademark system has a set of rules, soon to change in June a little bit, but a set of rules that relate to determining who's entitled to the use of a trademark. So for example, if 2 or 3 people are using a similar trademark in the same industry, basically the first person to have actually used it or the first person to have filed, the earlier of first use or filing is probably the person who's going to be entitled to the registration. So generally speaking, multiple people can use a trademark and or can even register a trademark in Canada or in most countries. At the same time, so long as it's in non-confusing channels of trade, the test really is whether or not the consumers in one area would be confused by the presence of another trademark in the marketplace. So the earliest user in a particular channel is typically the person who's entitled to register the mark. So in terms of entitlement and priority, these are kind of the different categories of assessment that we would do. The first person to have actual use of their trademark in the country. So for example, a trademark used on products is used when it's marked on a product that's sold. So sales of the products bearing the trademark is the actual use date in respect of products, versus in respect of services. So if you have a cleaning company or a computer programming company or something like that, the actual use of the trademark from a use determination perspective in the trademark law isn't the date of first sales, but actually the date of advertisement of the trademark in conjunction with the services and the availability of the services in the marketplace. So actual use that's one basis on which you can seek to protect a mark and to establish a priority position in respect of a trademark. And so, for example, if you have a company, you may have a company. I have a client who I filed a trademark application the other day for a company who our date of first use actually was in the 1920s. They haven't filed the trademark application until now, but first use was in the 1920s. So 1920 is actually the sort of the priority or entitlement position that we would have in the marketplace in their particular channel of trade. Second type of an application that you can file at the present time in Canada, and second basis on which you can seek to protect a trademark, is on the basis of proposed use in commerce. So effectively reserving a trademark that you haven't yet used. So the proposed use application, your priority date that you're entitled to is actually the filing date of your application. So if you have a trademark that you haven't used yet, but you've kind of maybe done a search and you want to put a stick in the ground on the mark, you can file a proposed use trademark application, which would allow you to get in line, so to speak, before someone else who might come along after in the same channel, and sort of beyond the registration, beyond the registrability and registration. So even separate and apart from filing the application, that may also sort of crystallize your position just on a use basis in the marketplace. 3 other categories of entitlement that exist, most of which would probably not be applicable, guessing, in terms of your companies, but one of them is you can file an application and be entitled to a registration in Canada on the basis of foreign registration and use of your trademark. So if you have a trademark that if you're a foreign applicant, so a lot of the work that I actually do is for American and foreign companies selling products and services into Canada, and we can oftentimes claim priority in their application based on the fact that they have registration and use of their trademark in their home jurisdiction. Another option that exists is called making known, and so if the trademark has been made known in Canada but not used, you can actually make a sort of an altered use claim on that basis. Lots of times where you would use a making known claim would be to say that your trademark, lots of companies even, sometimes companies in physical proximity to the US border, lots of times if there's spillover sales or spillover advertising across the border into the other market, you might argue, for example, an American company from Minnesota might argue that there's spillover marketing in Manitoba or Manitoba and Saskatchewan or something because their product is easily available back and forth, those types of things. Making known is another category in any event. The final category of entitlement or priority that I would just point out for you here now is there's another category of marks called public authority marks, and these are trademarks of, kind of by its name. A public authority is a government body, so whether that's sort of a municipal / provincial / federal actual government. So for example, the government of Saskatchewan or a particular ministry of the government of Canada or those types of things. Or other entities who can claim that they are effectively funded / controlled / authorized in the marketplace directly by the public, by a government, a body. Those are the other group that can claim rights as a public authority. Public authority rights, if they're available to you, are good. I often kind of loosely refer to the public authority registration as kind of the Uber trademark that the government created for themselves in the Trademarks Act. Where in most trademark applications we have to kind of delineate the channel of trade in which we propose to do business so that we do business. A public authority mark can be applied across all channels. So it can be used to kind of really broadly protect or exclude others from the marketplace. So public authority marks, for private companies, the primary place that you will encounter public authority marks is they might from time to time be cited against you in your trying to protect your own trademarks. There's some ways to try and get around that, but that's probably the primary interface that you would see of those. The thing I would point out right now here in terms of a change to this chart is, let me see if, I'm going to actually see if I can make this little clicker work here. The primary change that's going to happen in the Act in June is the, just going to try this here, let's see. No, I don't think I'm going to be so lucky as to actually figure out how to draw on the picture for you here, but here we go. Oh, wow, look at that. So the biggest change is coming up here on the actual use and proposed use marks. One of the primary changes that's being made in the Trademarks Act that's coming into force on June 17th this year is the removal of the need to file declarations of use on a proposed use mark and the removal of the requirement or the option to provide a date of first use in a trademark application. So the system that we have now is very similar in parallel to the US system, where it's based on use. The system we're going to have post June 17th is more Eurocentric. It's similar to the European system, where there's no need to declare use. And so what that practically speaking means that at the filing point of the trademark process is that people can file trademarks honestly with no immediate intention to use them. So there's probably some benefit to filing before those people if you have trademarks that you're worried about sort of squatters coming or something. But this is going to change. This piece of the law is going to change substantively. And again, we can kind of get to that as the time comes. But there's going to be substantial change here. Sorry, I'm just going to check quick here. I see Sherry had a question. Business name not trademark from first use. So I will actually address this one here. There's a question about, there's a question about if you have a business name that's not registered as a trademark. So your business name, what you might find with a business name is you may find that when you go to register a business name, the Saskatchewan Corporations branch or ISC, they do a search. It's called a nuance search, and it's got a list of previously registered business names and those types of things, and they won't let you register a name that's too close to another business name. there's a trademark section on the back of that report in which they do a very rudimentary trademark search also, where they'll kind of look at the first 10 or 15 occurrences of a remotely similar trademark in the Canadian marketplace. And you might, again, have to argue your way around or get permission around something like that. Your business name, registering your business name, effectively, it doesn't give you trademark entitlement in Canada. What a trademark registration will do is protect your brand across the country. The business name registration protects you in the corporate jurisdiction in respect of the business, but it doesn't necessarily protect you in respect of the actual products or services. So oftentimes I would recommend that in due course, I mean, it may not be something you think about, you necessarily think about right on the very front end of your product launch, but it's not a bad idea to think about trademark registration alongside your business name registration as some added insurance on the business name. You may also want to think about from the perspective of business name registration versus trademark registration. If your brand that you're proposing to use is the actual corporate name, so you know it's XYZ Corp, and the trademark you're going to use on your products is XYZ. Another thing to think about, and just to kind of keep in the back of your mind, is that the business name search that you do won't necessarily give you, I would suggest, won't give you sufficient comfort as to the availability of XYZ as a trademark versus as a business name in Canada. So you probably want to do an actual trademark search there. Again, there's some more, we get into that in some more detail, but that's kind of not a bad idea to think about in terms of, in the longer term, it's not a bad idea to think about having your business name registered and registering it as a trademark. Clearing it as a trademark at the front end of the process rather than further down the line isn't a bad idea, because frankly, the thing you don't want to do is you don't want to, for example, get to the point that you go and launch your product and you start using the name and you find out that, well, you know, there's somebody who was using an unregistered similar name, you know, in Nova Scotia, or you go try to expand to the US market or those kinds of things. So better information can lead to some better decisions on the front end of the process. In terms of the registrability of trademarks, a few things that to think about from the, and again, these tests are going to kind of change a little bit with the new act in June, but similar concepts will still apply. When we file a trademark application, some of the reasons that the trademark office might object to a trademark being registered could be that the trademark is, for example, descriptive. So, for example, you can't register a mark that's descriptive of the product or service as a trademark such that you would take it away from other legitimate competitors. So the example there is, you know, you couldn't register the words ice cream as a trademark for use on ice cream. You could probably register, you know, John Smith's ice cream or something like that. But descriptiveness, and then similarly, the extreme polar opposite end of that spectrum is you can't, they also will object to a mark that's deceptively misdescriptive of the product. So if it suggests that it's a product with a particular character or quality, but it's the exact opposite. So the descriptiveness, misdescriptiveness thing is one element of sort of the distinctiveness of your trademark. Another bar to registrability is if the trademark is considered to be primarily merely the name of a living person. So, for example, if it's primarily merely the name of a living person, you can have troubles obtaining a registration. Subject to, if it's the name of your design or you're a designer or something like that, there's a way to kind of do a consent and get around that. But sort of using the name of an individual, like that, usually it's the surname of an individual, is another issue that sometimes we need to overcome. The primary set of issues that people will have encountered and or may encounter in the filing of a trademark application and in terms of trying to get something registered would be if the trademark office finds another trademark or public authority mark that they believe in your particular channel of trade is confusingly similar. So what happens in terms when you file a trademark application. I guess some of the typical steps that would be involved in the trademark process. Oftentimes, the first thing we would do would be do a search. We could do a trademark search to identify if there is something else out there that's confusingly similar or some risk in the marketplace. If it looks okay to proceed, then we would go to the second step of filing an application. So once we file an application, the trademark office will do an internal search and come back to us and say, look, we either object to the way you've described the business, or we found a couple other trademarks that we think are kind of confusingly similar. This confusingly similar test is the primary piece to keep in mind here. So again, as I had said before, two trademarks can be identical as long as they're used in sufficiently distinct channel of trade that there wouldn't be overlap. So the primary piece to think about there is in that internal search, if the trademark office finds, Joe Smith versus John Smith as two marks in the same channel, they might try to raise an objection to registrability, et cetera. There, we'd have opportunity to sort of argue back and forth on these things. Presumably, procedurally, if we can get past those citations, the trademark will eventually register, and you'll be the owner of your rights in the mark. In the Canadian context right now, the term of a trademark registration is 15 years at a time, and it's renewable indefinitely in Canada. So 15 years at a time, we'd have to renew it. The rule is going to change again in June to 10 years, but it's a renewable thing, registered for those kinds of time periods. Two other questions here were related to, is it true that name registration is not required for sole proprietors? So business name, I guess the business name registration, you'd want to check this, but I don't typically sort of practice in that particular area. But if you're using, as a sole proprietor, if you're using a business name instead of just your own name, I believe that you do need to potentially register that under the Business Names Registration Act. It's a different act than the Corporations Act. Another question here was, is if you have a trademark and a logo, are they both as important, or how would you prioritize those in terms of registration? If they're together, I mean, I would virtually always suggest that registering the word trademark is the strongest way to go. I mean, ideally, at some point you could protect them both if you wanted to, but if you're starting a company and otherwise, let's face it, money and time are scarce. If you have to pick something to protect, I would suggest that probably the starting point would be to pick the word mark, because the word mark, if you protect that, gives you protection regardless of the way that it's presented or the font that is presented in, or those types of things. One of the other things that you'll need to keep in mind as you build your business from a trademark perspective is your international strategy. So and if people want to copy these slides afterwards, I think that Caitlin and Diane have them, or I'm happy to send them to you. But international strategy will effectively, from using Canada as an example, because here we are. As your market expands, you potentially need to think about protecting your trademarks in the other countries where you're expanding to. There's two key treaties that apply, one which is called the Paris Convention on Industrial and Intellectual Property, I think, and the second one is called the Madrid Protocol. The Paris Convention Treaty effectively provides a means for us to file up to 6 months after a Canadian filing of a trademark and claim the benefit of our Canadian filing date. So if, for example, we filed today an application in Canada, we could file up to August 12th in the US or Europe or somewhere else, and claim the benefit from a priority perspective, claim back to our February 12th filing date, so that we could, you could get back in front of anybody who'd filed in the meantime. So one of the things to think about from an international strategy is kind of mapping out the timing of your trademark filings to match your arrival in a marketplace. Also, if you're going into foreign language markets, there may be additional kind of elements to a search that you want to consider. So, for example, considering whether there's local translation issues, A friend of mine works for a food company in the States and told me that one time the marketing people in his company sent a search down for them to do in China, and the direct sort of Chinese iteration of the mark that they were proposing to use was something in the realm of your mother is a cow or something like that if you translated it directly. So they had to go back to the drawing board on that one and come up with a new mark instead of just doing a local market clearance of the mark that they had chosen for use in English language markets. Couple other things to consider here. There's another treaty called the Madrid Protocol, which again is coming into force in Canada in June, which permits for international filings in a number of countries at the same time. I'll leave it there for now, but there is a mechanism by which that you will be able to file in multiple places at the same time. Other things, just in international strategy to think about is just the timing and clearance. So, for example, if you're searching a trademark in Canada and you're thinking that you are eventually going to want to launch your product into the U.S. marketplace, you may want to search in the U.S. at the same time, simply to make sure that the mark is clear in both places, so that you don't turn around when you get to the U.S. market and find out that there's somebody already there. Final thing to think about on trademarks, and I think we'll move on to copyright, is in terms of trademark infringement. The test for trademark infringement, lots of people are sometimes interested in this. The test for trademark infringement is very similar to the registrability tests. It's likelihood of consumer confusion in the channel of trade. So in a particular channel of trade, trademarks that are used side by side that could cause confusion would infringe, or whereas if they're used far enough apart or the marks are distinct enough, it would be okay. One of the elements of that test is who is the consumer. So for example, if the consumer is guy buying stuff in the grocery store, like if you're using two similar trademarks on laundry detergent that would be 2 feet apart from each other on the shelf in the grocery store, there's probably more likelihood of a quick, confused purchase decision versus if you were using the trademarks on, products that would be sold in different stores or through different channels, and the marks were a little more distinct. I'm going to move on from trademarks there for now, but I can kind of come back if there's questions at the end. Copyright is another thing that you will find that exists in most companies and in most projects. Copyright, most people are kind of at least abstractly familiar with the concept of copyright. Copyright is sort of economic and moral rights that are associated with the effort of an author. And those, in certain cases, though, the copyright protection crosses over with trademark law. Copyright is created in Canada under the Copyright Act, so it's really the Act defines what copyright is. There's not really a pile of common law that extends the concept of copyright outside of the Act versus some of the other concepts of IP, which are created not by statute but by common law, can be a little more arise more from judicial interpretation. Copyright exists in a fixed work, so that you actually have had to sort of fix the form of the work. So if it's a written work, for example, you actually have had to have written it down. If it's a painting, it's painted. If it's software, music, whatever, those kinds of things. There's lots of different kinds of things that can be protected by copyright. Those include sort of images and artistic works, written work, so anything from a book or a manuscript or an article through to other things like that. Software, computer software, both the source code and the object code can also be protected by copyright. Sound and video, so sort of music and videos and those kinds of things are also the subject, and performances are also the subject of copyright. And there can also be 3D copyright, so copyright in, for example, buildings and blueprints, those kinds of things. Those are, may or may not, I don't know if anybody's in the architectural business, but that's sometimes something that can be of interest also. There's two sort of categories of rights in copyright. There's the economic rights and the moral rights. So the economic right that's given to you as a copyright holder is the sort of exclusive right to reproduce your work, to perform your work if it's a creative work that requires performance, to translate or rent the work, and to publish. So this is kind of a list. There's a little more detailed list actually in the Act, but these are sort of the general categories of, as the owner of the copyright, these are the things that as the owner you are exclusively entitled to monopolize or do. The second category of rights, and so these economic rights can be sold or transferred. So as an author, for example, you can transfer your rights in a work to a company or those kinds of things. So, and once you transfer your economic rights, you're no longer the owner of them. So they can be transferred or sold. The second category of rights are moral rights, and moral rights are sort of the rights of the author to protect the integrity of their work. So to protect the author from unauthorized use of their work, such that their notoriety or reputation in the work, as it might be known, would be negatively affected. This oftentimes is most applicable in the artistic area. For example, if you were a famous painter and you painted a picture of some person's face or something, you painted a portrait, somebody bought the portrait from you for $15,000 and hung it in their local art gallery and painted a mustache on it or something like that. You could argue that, such that people were confused and thought that maybe you as the artist had done that. You could try to make a claim of an infringement of your moral rights in the work. Moral rights can't be transferred. So as a company who's buying, for example, copyright interest in something, you can't buy the moral rights in a work, but the moral rights can be waived by the author. So, I mean, it's kind of fine print, but it's something to keep in mind, because moral rights can sometimes occasionally come up as an issue, and you want to be in a good position to kind of deal with that. Who owns the copyright is sometimes an interesting issue. And so with every different kind of IP, there's a different set of statutory functions of ownership that might apply. So with copyright, in the first owner of a copyright are the authors. So one or more authors of a work are potentially the first owners. From there, if the authors create the work in the scope of their employment, and these are the rules that are applicable in Canada. Again, they change a little by country. For example, in the U.S., the rules are explicitly a little bit different. But basically, if you create the work in the scope of your employment, then your employer can argue that there's a statutory presumption. You don't even have to sign a transfer. The employer can just argue that they own it. Similarly, or by extension of that, if it's a commissioned work, so if effectively if you're paid to create the work, as it's a commissioned work, then the commissioner can be the owner of the copyright instead of the authors, and or, as I had set up above, the copyright can also be transferred by an agreement. So, thing to keep in mind as a starting point in your company is the authors are probably the starting point, first owners of the work, and from there, if they're so what you want to do, and applying this to your company, if you've got copyright assets in your company, so for example, manuals, training materials, books, website content, all these kinds of things, and you want the company to own it, you can reasonably infer that if the content is created by employees, that the company can simply claim ownership on the basis of the employment relationship. This is the primary spot where there's a difference with the U.S. law. In the U.S., you have to do some different things to claim ownership of works for hire, they're called. But what you might have is content that's created for you by contractors. So lots of people just hire contractors to do kind of job work for them or piecework for them from time to time. And again, you could rely on the statutory presumption that it was a commissioned work, but my suggestion often with those types of things is simply to get a contract, like get a basic little contract put together, put it in the language that you use in your contracts, so you've got an understanding that your company is the owner. It's just a little easier that way if you have to deal with that at some point in the future. Registration of copyright is not necessary in Canada. It does provide, copyright exists sort of at the time your pen comes off the page, so to speak. But registration of the copyright does provide some significant enforcement rights. it flips the evidentiary burden in the case from the from you having to prove. There's about 7 different elements to prove a copyright interest, versus if you register your copyright, you don't have to prove any of that to enforce, and it kind of flips the entire burden over onto the defendant. The other thing that you can keep in mind is it's a good idea to use a copyright notice along with either, or even if you haven't registered, it's a good idea to use a copyright notice. I think I have a note on my website about some sample language copyright notice, but it's pretty simple. You see them on everything, copyright Smith Corp 2019, whatever it is. So feel free to email me or check out the website if you're looking for that information on the copyright notice, but that's a good thing to use. And again, there are similarities and differences between countries. If you are in a copyright-intensive business such that you need to protect and/or exploit copyright in multiple countries, there's another sort of set of laws and rules that will apply. Beyond copyright and trademarks, there's a number of other different types of IP rights that you might encounter. So you'll find patents, for example, from time to time. Patents are typically used to protect the functional utility of a product or a method, those types of things. For example, in the software business or the manufacturing business, those kinds of things, you probably might encounter more patent subject matter than you would encounter elsewhere. Industrial designs are another type of an intellectual property protective regime that exists in Canada, the U.S., many countries. In Canada, these are called industrial design registrations. In the U.S., they call them design patents. In Europe, they're just called designs. So there's a little bit different language applies, but similar kind of concept. An industrial design registration effectively protects the visual appearance of a commercially produced article versus producing its function. So it explicitly protects something that's non-functional. So maybe the shape of this water bottle might be the subject. Oh, it's pretty plain. It might be the subject of an industrial design, but the shape of something versus its function. So patents, industrial designs. Another type of intellectual property rights that exist, which are non-statutory in Canada, so they're not protected by an act, but they're protected by common law, so by judicial decision making over the last 100 and some years, are trade secrets and confidential information. So anything that, if you have trade secrets in your business, anything from, customer lists and basic kind of accounting information and those kinds of things, through to if you've got for example, a software program that you're treating as a trade secret, those kinds of things. These aren't protected by statute, but they're protected by, they're protected by common law. And the best way to protect these types of things are to protect them by using a contract. So for example, in your company, it's not a bad idea to have basically a basic trade secret or confidential information ownership and treatment provision, even in your employment agreements with your employees, just so that you have created the basis on which you don't want your sales manager to walk off and go down the road and take the customer list with you. If you have if you have a contract in which they've agreed that information is proprietary, confidential, and valuable, that's not a bad idea, not a bad place to be in terms of if you do actually have to make some kind of an enforcement action. So, and then there's other types of intellectual property rights that also exist that I won't get into in any kind of detail here now, but for example, integrated circuit designs, so computer chip designs, plant breeders' rights, those kinds of things. I'm happy to talk about those offline if you wish, but I decided to kind of just honestly kind of gloss them over to get us to the point that we got to the finish line a little more quickly here. So in terms of identifying intellectual property in your business and sort of figuring out the types of assets you have and what you might want to do with them, as you kind of look around in terms of assembling the landscape of intellectual property in your company, one of the kinds I want to think about are, intellectual property assets are typically used to protect yourself and your company against some kind of third-party activity, whether that be, an infringement or misappropriation, or, positively you want to create a licensing opportunity or a revenue opportunity. There's different kind of, lots of times what we do when we sit down and try to build an IP strategy for a company is to figure out who are the audiences of people that we might have in play that we want to protect ourselves in respect of. So, for example, this is probably not an exhaustive list, but one list that you could look at would be, protect yourself in respect of relationships with your customers. So you want to make sure you have all the necessary rights to the IP in the product you're selling to your customer so that your customer has freedom to practice and use what you sell them. And you also want to be in a position that they can't rip you off if they decided to do so. Other groups would be sort of distributors, manufacturers, those kinds of parties. You may have agreements and sort of use frameworks for either inbound or outbound IP rights in either of those cases. Licensees. So, for example, if you want to create licensing opportunities, you might need to take a little bit different approach to how you characterize and build your strategy and your portfolio, depending on what your licensing strategy is. So, for example, if you're planning on licensing industry by industry or country by country, you may need to take a little bit different approach to how you sort of register your patents or your trademarks or those kinds of things. Obviously, you also want to be in a position to protect yourself against third-party infringement. And then depending on what your ultimate business plan is, sometimes people are sort of already from the beginning planning towards an exit. Depending on what your exit might be, if you're in a software company and your proposed exit you're planning towards is, Microsoft is going to back up a dump truck full of money to your building and fill your garage with cash, you might take a little bit different approach. You might build your portfolio in a little different way to approach that kind of a transaction than you might if your long-term exit is, for example, is no exit. We're just going to carry on and hold the business closely and do whatever. There's lots of different options there, but keeping these different audiences in mind as you identify the IP assets in your company is a good thing. I talked briefly about who owns the rights. The ownership of your IP rights depends country by country as well as IP type by type. So there's a different set of statutory ownership presumptions that apply to patents, for example, than trademarks. And you need to be aware of those country by country just to be sure that you don't take some steps in Canada, for example, that have depending on where if your key market is in the U.S., for example, or you wouldn't want to take a step on something in Canada, for example, in patenting something. You might not want to forego patent claims in Canada on subject matter that wasn't patentable in Canada but is patentable in the U.S., those kinds of things. So who owns the rights is something to keep in mind. I guess the primary thing that I suggest that people try to do pretty early in the process as you're building out a business plan or building out your business is to kind of build and maintain an IP inventory. So getting kind of a list together of what are all the IP assets that you own, what are some other assets that potentially you might want to create. This all kind of goes hand in hand with building your business plan and your geographic plan. But certainly you want to identify both registered and unregistered properties. So if you've got trademarks in the trademark realm and copyright realm, for example, you may have lots of trademarks even that you use that aren't registered, which is okay. You just want to be sure that you kind of keep a list of those so that you can kind of keep an eye on and monitor them. This type of information, when you couple that with sort of what your geographic footprint plan is and competitive information, gives you the best ability to kind of make the best cost efficient decisions to protect your IP. So you may not, for example, want to bother with filing trademark applications in India if you're never going to do business in India. But it may be the case that if you're planning on being in Mexico in 3 years, that it makes sense to file an application in Mexico sooner rather than later. So those kinds of things. I think that the best way to make the best strategy and make the best plan is built on an inventory like this that's responsive to what the facts are. So once you've got an inventory in hand, you can figure out the best approach in the market. one other question that I had here, and we're pretty much finished, and then I can take a couple more questions, or like I say, happy to sort of speak offline with anybody that has further questions also. The one question that I had here was related to copyright. So if you advertise in the context of, for example, an art business, those kinds of things, if you advertise your work on the internet, it is using a copyright notice sufficient? I would say that using a copyright notice on as you advertise things frankly is about the best step that you'll have, short of registering the copyright in every work that you have, which I think is probably overkill. I mean, if you ever have to enforce, the good thing with copyright, if you ever actually have to enforce a copyright, it literally takes days to register, versus like patents and trademarks can take years to be completed, but copyright takes days to register. So if we ever do actually need to register something, we can do it quickly. So using a copyright notice is a good idea, I think. Lots of times people will also even just sort of use the kind of copyright watermarks right in the artwork that they post. I think using a copyright notice is a good basic step that you can take that doesn't incur a whole pile of cost. At least puts you in a position to, if you ever have to assert a claim of copyright ownership, you've done that. Putting photos of your work on Facebook or Instagram or something like that. I mean, honestly, the photo has copyright in it. Somebody misappropriating it and using it elsewhere would constitute an infringement. The question then that you have is, I mean, it's not necessarily going to be easy to enforce in that situation, and really, the government doesn't do that for you. You kind of have to do it yourself. So it is what it is in that realm. But certainly using photos that you've taken in social media channels you shouldn't have any kind of a defensive problem. You shouldn't have to defend yourself against a third-party allegation of infringement in the photo if you took the photo. Offensively, again, you're going to use them to promote if you're going to use them, and you just kind of need to be in a position to potentially, again, rely on, if there's a copyright notice that's used, etc. Watermarking that right onto the image isn't necessarily a bad idea. So I guess subject to, I'm going to keep an eye on my little window here for another 15-20 seconds, but subject to anyone else having any other questions. Again, I guess my email address is here, and I'll happily circulate these slides if anybody has any questions. I'm happy to answer any other questions, and hope you got a little bit of value from this. And I'm happy to hear from you offline if you want to talk more specifically about a fact pattern that maybe more specifically applies to your company or something. But hopefully you got some value here, and if there is anything else I can provide, I'm happy to do it. And thanks very much for coming today.